Hello everyone and welcome back. This session we'll look at what happens when the law decides to lift or pierce the corporate veil. As we've learned before, incorporation creates a separate legal personality for the company, meaning that the company exists independently from its members. However, in exceptional cases, courts or legislation may look behind that separation to hold individuals responsible for what would otherwise be the company's obligations. This process is known as lifting the corporate veil. Before we dive into the exceptions, let's quickly recap. Normally, the company's creditors can only claim against the company's assets, not those of shareholders or directors. This protection comes from limited liability, but this separation can sometimes be misused. For instance, when someone hides behind a company to commit fraud or to avoid legal duties. In such cases, courts may decide to lift the veil and look at who is really behind the company. As Stoughton LJ explained in Atlas Maritime Company SA and Avalon Maritime Limited, to lift the corporate veil or look behind it should mean to have regard to the shareholding in a company for some legal purpose. Lifting the veil allows the court to examine the people controlling the company when justice or statute requires it. There are two main ways in which this can happen: by statute and by common law. Several statutes allow or require the veil to be lifted. For example, the Companies Act 2006 allows the veil to be lifted in order to check that the trading certificate and share capital requirements have been issued and are in order. Section 993 of this Act deals with fraudulent trading, which is a criminal offence. In terms of the Insolvency Act, there's also a section on fraudulent trading or wrongful trading. In terms of the Company Directors Disqualification Act, we can look at the directorships of companies in order to investigate misconduct. So all of these examples show that sometimes statutes permit looking past the company's separate personality. In other words, looking at who owns the company and who runs the company. The courts may lift the veil. We're now moving from statute to common law lifting of the veil, and by this we mean the lifting of the veil by the courts. So the courts may lift the veil when a company is used for a fraudulent or improper purpose. For example, in Guildford Motor Company and Horn, a company was used to avoid a non-competition clause, and in Jones v. Slipman, a company was used to avoid a property sale. In both, the company was created as a facade, a smoke screen to conceal the truth, and the court said the company cannot be used like that. Public policy can also justify veil lifting. For example, in Daimler Company and Continental Tire and Rubber Company, an English company controlled by German nationals was treated as an enemy company. This obviously was during the First World War, the Great War. So policy issues allowing us to lift the corporate veil is very, very rare. You can imagine the First World War, Great War was very exceptional circumstances. In Smith, Stone and Knight, a subsidiary was held to be an agent of its parent company by which it was completely controlled. So the courts also lifted the veil when they found that a company was used as an agent for another company. Whether or not one company is actually an agent for another is a question of fact. Finally, when we look at groups of companies, you have to remember that generally each company in a group is separate. So the subsidiaries are entirely separate from the parent company, even if the parent company owns all of the shares in the subsidiary. This was confirmed in the case of Adams and Cape Industries, even where a group structure limits liability. So in other words, where companies are created specifically to limit liability, that is fine as long as it's not done to evade an existing obligation. In this case, a summary of the general principles were given up to the most recent case of Prest versus Petrodel, which we'll look at in a second. There are only three circumstances in which the veil of incorporation may be lifted: if it's mandated by statute, or secondly, a company is found to act as an agent of another, or thirdly, if company is held to be a mere facade concealing the true facts. The UK Supreme Court clarified that the veil may only be lifted where there is an existing legal obligation or liability or restriction and the company was formed expressly in order to evade that. And this then results in that obligation being deliberately evaded or frustrated. And like I said, this was the only reason for creating the company. And this was decided by the Supreme Court in the case of Prest versus Petrodel. In Prest itself, the veil was not lifted because there was no evidence of evasion. An existing company was given ownership of certain property by the owner of the company. And the court said, well, this company was not originally created deliberately to evade an existing obligation or liability. So the veil was not lifted in that case, but do go and read the case because it also engaged other areas of law, such as trust law. Separate personality therefore remains the rule, but it's not an absolute one. Thank you for watching. Understanding when and why the corporate veil can be lifted shows how company law balances the benefits of limited liability on the one hand with the need to prevent abuse on the other. See you in the next one.